I'm really glad I get to be the moderator for this next subject because it's been a big water cooler discussion in Seattle as we went to the $15 an hour wage. And it's really become an emotional issue among friends because, you know, there's always an argument on both sides of how it's going to affect business. And in racing, we've kind of skirted the issue for a long time. We've skirted the issue of 40-hour work week, contract, subcontractor issues. And a lot, I think, it was because we were kind of family businesses. And now the whole workforce in racing has changed to be more diverse and more actual employees coming to work, and it's created some problems for racing. That the only thing I've ever heard from our trainers when we bring it up is, boy, if they ever start enforcing that, we're done. Well, guess what? They're starting to look at racing. But fortunately, we have 3 attorneys here today that are going to figure it out exactly what's going on and tell us what's going on and how we can fix it in our industry. And that's Peter Ecabert, Brian Fitzgerald, and Will Velie. And you can consult their bios or your binders for their bios. So we have, like I said, we had Seattle with a $15 an hour over the next 3 years. The governor of Kentucky announced a minimum wage for state workers. And we have the South going from $7.25 to $9. And does this really apply to racing? We pay piecework. The groom gets, depending on where you live, $14 a day per horse, $150 per horse. A Govt people get $15 amount. How do we convert that to hours, and how does that apply to racing? So I think Steve Asmussen's, the recent issue with Steve Asmussen when he got the lawsuit from the Department of Labor in Kentucky, was he just an isolated case, or is this something that's coming to racing? So I think I just want to start right off with our panel and talk about, do we have a business model that needs to be changed in racing on how we pay employees, or can piecework be converted to a 40-hour work week?
MaryAnn, I think, let me try and take a crack at it and then turn it over to the other guys, but I think that now the Department of Labor in the last 5 years have really seemed like they've really increased their efforts at coming after folks and trainers in the racing industry. And obviously the Fair Labor Standards Act doesn't apply to everybody, but it does apply to anyone that has any kind of connection with interstate commerce. And so it generally applies. And in fact, the problem is that agricultural employees are generally exempt, but being on the racetrack, you're not considered an agricultural employee. So your employees are subject to minimum wage and to overtime rules of the compensation. Now, like I say, that they seem to increase and intensify coming after trainers, and I think part of it had to do with the Nick Zito case. That was a New York case, a federal case, back in 2012 is when the ruling came down. And what it basically said that, the argument was made, well, this is the way we do it in the industry, that, we don't keep records. These hot walkers and grooms, we pay them 40 hours a week and we let them go home in the afternoons, and and so we've guesstimated that that's about right, and we just have to keep the records. Well, what happened in Zito was that they said, if you don't keep records, guys, it ain't going to work. So they brought the grooms and hot walkers and people in, and they had the depositions and testified. Well, we start about 4:30 in the morning, and we leave about 11:30 in the morning, and then we have to come back about 2 hours, and we work 7 days a week. Well, the Zito and his management folks are saying, well, that's not true. That's really inflated. But the courts have said that's too bad. If you had records, you could refute that. But without records, then that's your burden to keep the records and show accurate and reasonable records. Without those records, then we're going to accept the testimony of the employees. And Also, in that case, the court allowed for a class action lawsuit, which then that even hurts more, because then you join all those people that are similarly situated, and they're coming after you. So when that happens, you not only get to pay the overtime based upon some inflated standard that the employee happens to conjure up, but you also have liquidated damages that basically are equal to the amount of the overtime. So it's not a good situation. The other thing that's happened here recently, in June the 30th of this year, the Department of Labor released a proposed rule change. And basically in the rule change, what they've said is that there is an exemption for basically white-collar type workers, your management type workers and that sort of thing. But what the test is going to be now, they haven't changed that floor. It was at about $23,000. If somebody made $23,000, you could consider management, consider white collar, and you didn't have to cover them for overtime or worry about minimum wage. What the new rule that came out in June is saying is that standard is more than doubled. Now it's at $50,440 in order to be exempt under the professional employee type white collar exemption. Then in July of this year, July the 15th, they came out with what they call an administrator's interpretation, which concerns the misclassification of employees and independent contractors. And what that does, there's a new test, and basically you're asking about piecemeal, MaryAnn. The problem with that, there's a test, and it's like a 6-factor test. And one of the factors in that test is that how is the employee paid? Is he paid hourly? Is he paid by the job, weekly, piecemeal? That's one factor that goes into looking as to whether or not he's an employee or an independent contractor. But basically what they say, and the conclusion is really interesting in this 12 or 13-page interpretation that they came out on misclassifications. And like I said, that just happened July last month. And what they say is that in sum, most workers are employees under the Fair Labor Standards Act's broad definitions. The very broad definitions under employment under the Fair Labor Standards Act has to suffer or permit to work, and the Act's intended expansive coverage for workers must be considered when applying the economic reality factors to determine whether a worker is an employee or an independent contractor. The factors should not be analyzed mechanically or in a vacuum, and no single factor, including control, should be overemphasized. Instead, each factor should be considered in light of the ultimate determination. But what they say, the correct classification of workers are as employees or independent contractors has critical implications for the legal protections that the worker receives, particularly when this classification occurs in industries employing low-wage workers. So what you get from reading those factors and everything else that they're saying is that they're not going to be very kind with respect to independent contractors. It's going to be very difficult to have someone classified as an independent contractor, which I understand is going to be, I don't know what the cure to that is, but that's where we are.
I want to hit on something. I want to ask Brian something on of what you talked about, Peter, and that's that we're not classified, the workers at the track are not classified as agricultural workers. Now, if you have a training center and you're operating your business out of the training center, you can be classified as agriculture. I think it was Will Velie that first told me when we were working with H-2B visas that at the racetrack you're in the same, when we were talking about prevailing wage, we're the same classification as zookeepers and circus workers. And at times I do see the correlation at the racetrack. But how in the heck did it happen that we lost our agricultural status at the racetrack? And what can we do as an industry to get that back? Because that seems key. Brian.
I'll defer to you on that.
Well, I think that's something that we have to get the law changed, have to get with the department. And I guess Will has got more experience going up with Labor Department than any of us. So maybe.
Well, then the occupational classification that Department of Labor gives Horseman is non-farm animal worker, so non-farm animal. So they are considered non-agricultural, and we do have to operate under that with Department of Labor and the visas that we apply for. In the last 2 years, I have represented directly 4 trainers and to a certain extent, a fifth trainer in different actions that were brought by the federal government. 3 of them were wage and hour actions. One of them was a straight immigration action, but in all of them, they were spurred by employee complaints about some type of non-payment of wages or some type of working condition violation. And the federal government, when it comes in full scale. They don't just bring one agency. They will come in with wage and hour. After wage and hour, if they find anything, they will come in with Immigration and Customs Enforcement and do an I-9 audit. And if there's any type of tax violations, IRS comes shortly thereafter. So once you get the attention trained on you by the federal government, it doesn't typically let go until it's gone through a full-scale enforcement against you. And I was just reading the records. According to DOL's records, there's been a 23% increase in agency investigations in 2014 as compared to 2009. There's a 20% increase in violations found against companies, and 78% of all companies investigated had violations found. Violators can be sued for back wages and an equal amount of liquidated damages. That's for wage and hour violations. Then with I-9s, it's $1,100 per violation if that comes towards you. And then, of course, if you have IRS penalties, you're going to pay the back taxes for not withholding and possibly suffer severe penalties as well as criminal investigation. Their records show that 1.5 million workers have been paid back wages since 2009. $1.3 billion in back wages have been repaid, and in 2014, $240 million in back wages were assessed and paid to 270,000 workers. So that's a pretty significant number of investigations that have occurred in the last year alone. According, and I have the piecework. Their definition of piecework is that you calculate the number of hours worked, and then you divide it. You divide the amount of money paid, and that's the amount of money that they're paid hourly. And then any hours above the 40 hours, you then have to pay them an additional 50% wage. So for non-agricultural workers, the piecemeal rate does have to be paid time and a half for all overtime hours.
So as a person that wants to look for solutions, rather, when we hear the statistics, and I think that a lot of tracks, especially like my track is a smaller track, and Steve Asmussen is someone that probably has a large payroll or does have a large payroll, and I think that our horsemen tend to think that we're exempt. And as an HBPA person, what's the first step that we need to take to tell our horsemen this is a real issue, and what's the first thing they can do toward that? I mean, because we have grooms and exercise riders that say we're not going to complain, this isn't going to trigger an audit, but we know we're all that close away from something happening. So what would be the first step, and I'll open this to anyone that wants to answer, on starting to make this a realization?
Let Brian handle that, because I think the important thing is records, and I think Brian's got some stuff on that.
Yeah, I've got a fairly detailed answer, and I would be happy to give folks a copy of this. The burden is on the employer to keep proper records of the time worked by his or her employees. The Fair Standard Labor Act requires no particular form for the records, but does require that records include certain identifying information about the employee and data about the hours worked and the wages earned. The law requires that all this information be accurate, and the information they want is fairly extensive, and I'll run through it here. The records that an employer must maintain include: 1, employee's full name and social security number; 2, address including zip code; 3, birth date and if younger than 19; 4, sex and occupation, time and day of week when employee's work week begins, hours worked each day, total hours worked each week, basis on which employees' wages are paid per hour, per week, piecework. Is it a regularly hourly pay rate? Total daily or weekly straight time earnings, total overtime earnings during the work week, all additions to or deductions from the employee's wages. 13, total wages paid each pay period. Finally, date and payment and pay period covered by the payment. Records must be kept at a place of employment or in a central records office and maintained for a minimum of 3 years for the Department of Labor. Timekeeping, you may use a timekeeping method as long as it's complete and accurate. So you can use a time clock if a timekeeper keeps track of employer hours just by hand or tells the workers to write their own times on records, that's fine, but there has to be a written record of all that information. So it's fairly extensive and very specific, the requirements.
And how do you think that we bring this to trainers to actually believe that this could happen to them?
Well, I think you could give them just some of the experience that these folks are being audited and the requirement, with the consequences of it, and then give them the information they need so they understand what it is they have to do, so they don't have to go out and find the answer to what it is they need to do, that you give it to them, and they can decide for themselves.
Because the other issue is grooms and that want to work 7 days a week. We had a lot of roving grooms and offered roving grooms in the Seattle area to help them comply with the 40-hour week, and we had an uprising of the grooms that they wanted to make that extra money. So it seems like I said, a whole industry model change of the way we've been doing business.
Like
I want to ask a question along this line here, because the same thing, it kind of goes with what MaryAnn was saying. Because some of the grooms came to me when I was at Florida, and some of that was going on, and they say, what about if we want to be there? In other words, like they're not assigned to that horse, but they come, their employer was not letting them come to the races. As you know, they wanted to go to the barn, walk up with them, maybe carry the bucket or something like that, not just because they like being involved in it, and they weren't letting them do it because if they were actually doing their job, then they would be counted as on the clock, so to speak. And they were just wondering if that would, how that affects them, what they could do to be allowed to participate, because that's why they work. They enjoy it.
I think we've got a great example of that's understandable why the trainer would not want that, and that's in a fellow trainer in Kentucky who had a friend who wanted to become more knowledgeable, was on unemployment, wanted to become more knowledgeable about the horse industry and what was going on, and he was out there just on a volunteer basis with that understanding. They came in and said, no, you're there as you're doing work there, and we're going to account that, and we're going to charge the employer, and then you're going to lose your unemployment, and the employer's going to get a big fine and everything else. So I mean, so it's understandable that I think the trainer takes the right position that no, you can't do that, man. It's going to screw everything up. Okay. I mean, that's a legal term, screw it.
Yeah, I actually worked on that case, and we came to a very quick settlement on it because the trainer was exposed on other issues, and we thought that which rightly so, he did pay the person. He actually did pay them, but he didn't have record keeping of it. And so that was where the Department of Labor Wage and Hour officer said, if you can't prove it, you have to pay it, and I'm going to open this up to all of your employees and audit their hours. And so we looked at the amount, and it was not pleasant to do, but it was low enough amount to keep it managed. And that's an example of if you do push back against the federal government, they will bring all the agencies in, and they will find something.
That's another part of what they were talking about too, is that they would have a clock. Now that kind of helps, because like they say, well, what if we don't punch the clock in? If he gets a time clock, that would help us, because then if we just go and we don't punch in on the clock, well, but then they are not covered under the workers' comp rule. Then if they're not on the clock and they happen to get hurt when they walked over with them to the race, and so it just throws that thing up too. So just go having the clock and them saying, well, I'm gonna clock out, but I'm gonna keep working, doesn't fly either.
Well, that depends what state you're in. Because we had a groom went and watched the races and fell out of the golf cart and is now pensioned for life. So, yeah, you're a covered employee in Washington. So we're about out of time, and like I said, I think that we only touched on the problem. And what I'd like to propose as an HBPA, National HBPA, is to form a committee of sorts to actually create a paper that we can distribute to trainers to show where they're vulnerable. Because I mean, I get people audited at the state level, and we can't even get 2 state agencies to agree on what the law is. And so, but they expect our trainers to know the law. And to create just some guidelines, like should you have a time clock or shouldn't you have a time clock? Should you allow your worker to work 7 days a week if he wants to work, he or she wants to work 7 days a week? What kind of limits can you put on? How is that going to affect your workforce? And so that, it seems to me that education to the trainers is the best approach to this before the fact, rather than a huge crisis of someone getting audited and oh, we're in trouble, it's going to ruin us. So would love to see that, and would be like to be a part of it, and have the panel for sure, and anyone else to be, because I think this is a real issue that's probably a lot more detrimental to racing than LASIX is, as far as our demise or not, and would like to see this organization do that. So, thank you. Any questions?
I just have a statement and then maybe a couple questions. Being a trainer myself from South Florida, the 40-hour.
Hello? Being a trainer from South Florida, the 40-hour rule, very few trainers have their work help work less than that. Just mathematically, if you're working 6 days a week, 7 days a week, you're working maybe 6 hours in the morning, 5. And then mostly the grooms have to come back at least 2 or 3 times in the afternoon, whether they're running a horse or feeding. So I would say most trainers are probably having their trainer help working 50 hours a week.
Yeah, in some states, if you work someone 7 days, then even if it's not over 40, that 7th day is considered overtime.
Yeah, so my point by saying that, you could almost put a blindfold on and throw a dart against a wall with the trainer's names on it. Whoever you hit is in violation. Just would like to know, Mr. Velie, the numbers that you threw out, the 270,000 people and the $1 billion, was that within the agricultural industry, within the thoroughbred industry, or was that just a statement that just covered coast to coast of the nation?
It would be non-agricultural, and the top 4 professions were landscaping, construction, restaurant work, and I lost the 4th one, but horse racing was not one of those top 4. But you're absolutely right about being completely exposed in terms of wage and hour violations, and also I practice immigration law. Bula and I talk. We go to every track in the HBPA area, and there's a huge liability that's open and obvious. We're low-hanging fruit when it comes to immigration. So,
as far as the records, very few trainers would pass the smell test on the records. Many still pay cash or part in cash and things like that.
yes.
And then really my last question is, being a trainer, and every trainer possibly being exposed to the threat of what you just talked about, what triggers something like this? Is it just simply a disgruntled employee that makes a few phone calls that can turn this on you? Is it like the IRS that randomly picks people, or sees something about your procedures that kind of singles you out? What triggers this?
All the above. It can be PETA making a complaint against you. It can be a disgruntled employee who you terminated and is going to get back at you by making that kind of complaint. It can be the lottery, the audit lottery. You lose. Any of those things can happen. And the audit or the investigation can be, like Will is saying, they can come in and raid stalls, raid barns, and that can happen. But you also can get a letter in the mail saying, we want to see your records, we'll be there next Tuesday at 10 o'clock, have them there. Or they can say, come into our offices and bring all your records. There are a variety of things that can happen in that regard.
So what you're saying also is one of the federal agencies that may begin the process of investigation, if they come across something or if they feel you're not cooperating fully, then they can increase the scope of the investigation, not only within their own agency, but actually pull in outside agencies or outside to even make it worse.
That's exactly what they do. They pull a thread, and where that thread unravels, they'll bring in whatever agency they think has sanctionability over it. So they'll come in with wage and hour. If they find tax violations, they'll refer it to IRS. If they find immigration violations, they'll refer it to immigration.
One last thing, I have 40 horses. Does anybody want to be a trainer and take my spot?
One other thing, there are certain posters that as employers you're supposed to have in your work areas, and there's a handout from labor that's here if anybody wants to look at it. Most of them, there's not a penalty if you don't have it, but there are a few of them that do have carry penalties if you fail to post those. So that's here if anybody wants it, and if there's not enough, I'll get more copies and give it to you.
And on that same note, what we did in Washington for that is we placed those posters in each barn. We have large barns, we only have 11 barns, and that has sufficed for all the employees in each barn to have those posters. And so you can talk to your HBPA about getting those posters.
Yeah, and you can get those posters online by just with the Department of Labor, their website, that you can just go on.
Any other questions? Well, thanks very much.
About a round of applause for our panelists.